Good morning to all of you. This video is intended for CPC students. Today we are discussing order number 8, that is a written statement. So what is a written statement? In simple terms, you can say written statement is a counter statement to the plaintiff, a reply statement to the plaintiff. Please remember, both in the plaint and in the written statement, there will be pleadings. You have to write in the shape of pleading. That is, you have to follow the procedure under Order 6 from Rule 1 to Rule 18. There is no other go for you. Normally, as already told you while discussing Order number 3, or Order number 5 also I have discussed. Whenever the defendant is served with a summons which contains the copy of the plaint, then you are supposed to attend the court on the particular day, and you will be given a time of 30 days to file your written statement. Of course, it will be extended normally up to 90 days. It is only a rule of procedure, but we can't say it's not law. After 90 days also, if the court is satisfied, they can give you some extended times. Yesterday, I have showed you that written statement in the particular case. So please remember, in the case of Kailasnath versus Nanku, Kailasnath versus Nanku, 2005, Supreme Court, please said, held that 90 days provision, filing of written within 90 days, it is only, please remember, it is only procedural, it is only directory. You can't say that it is mandatory. Then I told you the denial should be specific. There should be no evasive denial. Already I called, except for the facts admitted by the defendant, other points they are put to the strict proof by the plaintiff. He has to prove the same. Like that, rule number 2, 3, 4, 5 are discussed. Now we are coming to the important rule number 6. 6 and 6A, they are very, very important. 6 is set off, nothing but adjustment. Please remember, this comes only in money suits. In money suits only. So there are two types of set off. One is legal set off and equitable set off. Don't bother about equitable set off. Legal set off itself is sufficient. So for this legal set off, nothing but it is a claim set up by against. Simply, A institute a civil suit against B for 12 lakhs, but B says, already this man has to give me 5 lakhs. Okay, you deduct that 5 lakhs, I am ready to pay the other amount of 5 lakhs. Like that, this is set off. So here the important point is the defendant is acknowledging the debt and he is filing another set off, another case that will be taken as a cross suit, and instead of deciding two suits, the judge will decide it in a single suit. Right? So this is very, very important for the set off. So I told you legal set off and equitable set off. Equitable set off is simply to say, suppose if you file a case of rent control, or you file a case rent control కింద వేసినప్పుడు you claim some 1,50,000. దానిలో అతను ఏం చేస్తా అంటే, దీనికి నేను రిపేర్లు చేయించాను, 50,000 ఖర్చు అయినాయి, మిగతా అది ఇస్తాను. ఓకే, దట్ ఈజ్ ఈక్విటబుల్ సెట్ ఆఫ్. అట్లా కొన్ని ఖర్చులు తీసేయటం, ఈక్వల్గా దీనికి బదులు ఇస్తాను, దట్ ఈజ్ ఈక్విటబుల్ సెట్ ఆఫ్. ఇట్ ఈస్ ఓన్లీ కోర్ట్స్ ఆఫ్ ఈక్విటీ ఇంగ్లాండ్, హియర్ ఇట్స్ నాట్ అలౌడ్. దెన్ కండిషన్స్. Number 1, the suit must be for recovery. That too, money recovery suit. So that too, it should be legally recoverable. And the sum should be particularly 100% ascertained. Both parties must accept the same. So claim set off ఇది కూడా ఒప్పుకుంటేనే, లేతే కాదు. సో కాబట్టి డెఫినెట్లీ దిస్ కెన్ బి యాక్సెప్టెడ్. 6A కౌంటర్ క్లైమ్. కౌంటర్ క్లైమ్ మనీ సూట్ కాకుండా మిగతాయి. కౌంటర్ క్లైమ్ ఏంటంటే ఏ ఫైల్స్ ఏ ఇన్స్టిట్యూట్ పార్టిషన్ సూట్ అగెన్స్ట్ B, C, D. Then they say, already we are having so many cases against him, but since he is a relative, we are not filed the case. Now, since the man has raked up the issue, please try to solve our case also. We have got a counterclaim. Ani, mana cases veste, they will be treated as cross suits. Please remember, counterclaim means a claim made by the defendant in a suit against the plaintiff. Here, it need not be money suit, partition suit, declaration suit, partnership, so many things will be there. Yes, there you can file the counterclaim. That means you can set up the counter case also. In CRPC, we call it as the counter case. Of course, before 1976, there was no such provision. After 1976 amendment only, this counterclaim system has come up. So please remember. Then, how to file the counterclaim? Please remember. Number one, you have to mention the same in the written statement, which is filed under Order 8, Rule 1. And sometimes you can file an amendment petition, that is 9 law, Order 8 Rule 9, rejoinder law. By amending the written statement with the leave of the court, with the permission of the court, then setting up, you can set him up. Of course, since you may not remember, then if you get knowledge of the same, yes, you can take permission of the court and file the counter statement, counter claim. And sometimes in a subsequent pleading also, you can file the so-called counterclaim under Order 8, Rule 9. That is rejoinder అని చెప్తున్నది అన్నమాట. Then please remember, who can file the counterclaim? Normally, the defendant, he has to file the counterclaim. Right? So, whenever the topic of set-off is mentioned, please don't forget to mention the very famous case of Balraj Taneja versus Sunil Madam, 1999. Second case is Jayantilal versus Abdul Aziz, 1956. Of course, Sunil Madam case is that you cannot dispose the case since the defendant is absent. అప్పుడు చెప్పాను దాన్ని కూడా వర్తిస్తుంది, రిటర్న్ స్టేట్మెంట్ వేయలేదు కాబట్టి. More appropriately, this case. Now coming to the counterclaim law, when very important cases, Gurbachan Singh versus Bhag Singh, BHAG, 1996. So this is the mode of setting up the counterclaim. You can file it even under Order 8, Rule 9 also. This is stated in the case of Ramesh Chand versus Anil Panjwani, 2003. Yesterday in the class also I have given you the name of this case law. Right? So please remember, set off, the differences. Set off is a statutory defense to a plaintiff's claim. Of course, counterclaim is definitely a cross action. Not only of the same subject, on the other subject also, you can file the counter case. Set-off is for certain ascertained claim, ascertained money. Right? Counterclaim is, of course, need not arise out of the same transaction. Then set-off is a very good defense for the defendant. And another thing is, defendant has to admit. This is the advantage. Defendant will admit that this man, I am due to him so much of amount. Legal set-off, definitely the amount recoverable at the time of the suit, right? But counterclaim means, please remember, the amount must be recoverable at the date, from the date of the written statement. Of course, likewise, some differences will be there. They are not that much important, but please remember, set-off is nothing but adjustment. This man has to give me this much of amount, has to give me this much of amount. Counterclaim is, a case is filed against you. Yes, I have got another 2 or 3 cases. Please club them and yeah. So they are called as cross suits. And lastly, the plaintiff may become a defendant in the legal set-off. At the same time, defendant may become a plaintiff in the counterclaim. Likewise, that's why it's called cross suit. Of course, the Honorable Court will decide at one stretch instead of giving them a number of other things, number of OSs. They will not give separate OS number. In this OS number itself, they will decide the case. That's the advantage of set-off and the counterclaim. I hope you have understood. Now I can't say well, but you have to go through the Order 8. You have to go through the rules. Then only you will be able to appreciate. So hear my video once or twice, then read the book. Definitely you will get advantage, because as long as you are the civil lawyers, you must be thorough with Order number 6, 7 and 8. Okay, with this I am concluding. Thank you very much.